Also, there will be questions at the end. I'm going to leave questions right at the end after Dr. Kyriakides' paper. Dr. Klearchos Kyriakides, his paper is titled "The Rule of Law Vacuum, Ethical Deficit and Contradictions at the Core of the Cyprus Question." Very pleased to have Klearchos with us again. Klearchos Kyriakides is a senior lecturer, non-practising solicitor at the School of Law at the University of Hertfordshire. He's also an executive member of the Hertfordshire Law Society, the West London Law Society and the Society for Modern Greek Studies. He's also a former research fellow at the erstwhile Royal Air Force Staff College and a past president of the West London Law Society. He holds a degree from the University of Birmingham, MPhil and PhD in international relations degrees from the University of Cambridge, and a postgraduate diploma in legal practice from the University of Westminster. As I said earlier, and as Professor Coufoudakis said, Dr. Kyriakides also co-authored the case against Anne Black in 2004. He needs no introduction. We're very happy to have Klearchos with you. Thank you.
Thank you very much, Costas. And I must also at the very outset congratulate Professor Coufoudakis for visiting us and for his contribution to scholarship over the decades. One of my first experiences as a student was to pick up a book written by him, and I've been influenced by his ideas and scholarship over the decades, and I'm particularly honoured to be with him this evening. I'm grateful to Lobby for Cyprus for inviting me to address you once again. I must begin with my usual caveat, which is to the effect that what I have to say this evening represents my own views and not the views of any organisation. The title of my contribution is "The Rule of Law Vacuum, Ethical Deficit and Contradictions at the Core of the Cyprus Question." The phrase "the rule of law deficit" was used by the Secretary General of the United Nations without expressly referring to Cyprus when he referred to the rule of law vacuum as a concept which was evident in so many post-conflict societies. The rule of law is a principle of cardinal constitutional importance which lies at the very heart of the Commonwealth and the European Union, of which the Republic forms part. It is also a cardinal principle of the United Nations. Ethics is a concept which owes its philosophical origins to the great book of that name by Aristotle. And Aristotle hovers large in the story of Cyprus. One of the points he makes in his other great book, Politics, is that a constitution can easily be drafted and it can quite easily last for a day or two. The problem is that constitutions have a tendency to fall down, and the objective of any constitution-making process should be to ensure that a constitution lasts beyond the first day or two of its existence. Contradictions at the core of the Cyprus question will become evident as my talk proceeds. I want to do two things in the limited time I have available. The first thing to do is to outline some salient points of history and principles of law which govern and relate to the Cyprus question. And secondly, I want to zoom in on the origins, perceived rationale for, and risks associated with these twin concepts, bicommunalism and bizonalism. My central argument is that both of these concepts are anachronistic, philosophically unsound, morally dubious, and legally questionable. Let's begin now with a little bit of history, which you should hopefully be familiar with. The history of Cyprus, of course, goes back into antiquity, but the starting point for the modern era is, of course, the Zurich-London agreements, which were effectively imposed upon Cyprus as a non-negotiable precondition of partial decolonisation and independence. And remember that the Republic of Cyprus came into being subject to the terms of various treaties which gave rights to two of the former imperial rulers of Cyprus, Turkey and the United Kingdom, together with Greece. But what I want to zoom in on now is the concept of bicommunalism, because the 1960 Constitution, which was effectively imposed on the Republic, was predicated on bicommunal lines. So the bicommunal element of the bicommunal bizonal mantra owes its origins in the modern era to 1960, although it owes its historical origins to the Ottoman imperial era. Bicommunalism is an Ottoman constitutional concept. I'll say a little bit more about that later. But it's very important at the very outset that we identify those core principles. This is a map that's drawn from the official website of the United Kingdom Ministry of Defence. It's in the public domain. It's Crown copyright material. And you will notice from the map that the United Kingdom does not regard the Republic of Cyprus as de jure partitioned. It regards it as a unitary state, as indeed it is under the 1960 arrangements. The United Kingdom, as we know, asserts sovereignty over two sovereign base areas and regards the island of Cyprus very much as a British base. And Prince Harry returned from Afghanistan via Cyprus earlier this week. The operations in Afghanistan and possibly the discrete ones in relation to Syria are using Cyprus, one suspects. But that's very important by way of background. So the Republic of Cyprus did not come into being as an independent sovereign state in the normal circumstances one finds in Europe. It came into existence subject to concrete, binding, although that's questionable in a moral sense, and extensive, let me rephrase that, forgive me, came into existence subject to extensive rights claimed by Greece, Turkey and the United Kingdom. Did not come into existence free from the shackles that that other countries were free from. I'm going to move on, if I may, to the familiar history of the 60s and the 70s. The Republic did not join NATO. It chose in its wisdom to join the non-aligned movement. This exposed it to the tensions associated with the Cold War. In the 60s, we saw the intercommunal clashes, the constitutional crisis, and the acts of external interference, which marred the early years of the Republic's existence. And as a consequence of the activities, it must be said, of paramilitary organisations from all the communities in Cyprus, or the two main communities in Cyprus, if we can use that phrase, which I'm going to later attack, the rule of law was not properly bedded down. Even though the Republic was nominally established as a democracy, the rule of law, as we understand it in the European liberal West, was not embedded. The gun prevailed to a great extent. Politicians thought they were above the law, and external actors in the region behaved as if the law didn't exist. And then we had the Turkish invasion of 1974. And I really want to just read to you something from an English Court of Appeal case. Nothing annoys me more when I hear politicians here in Westminster use weasel words to avoid drawing attention to the reality of what occurred in 1974. Politicians, because they don't want to offend Turkey and they want to play the diplomatic game, love referring to the events of 1974, the episodes of 1974, the conflict of 1974. The English Court of Appeal, in common with a number of English judges, has chosen to call a spade, and in the case of Polypek and Marangos of 1998, a case in which the Marangos company lost on a point of law, the Court of Appeal stated that in the summer of 1974, Turkey invaded the island of Cyprus. By the 16th of August 1974, Turkey had occupied a large area in the north, amounting to just over 1/3 of the whole island, which the Court of Appeal referred to as the occupied area. And many members of the Greek Cypriot community in the occupied area fled in fear of armed force from their homes and businesses to the other parts of the island. Now, it was implicit in the use of the words invasion and occupation in that particular court case, and others, which I won't go into, that Turkey had violated international law. It had breached the terms of the United Nations Charter, which prohibit the use of force, save in very limited circumstances to do with the right of self-defence or with the authority of the Security Council, which didn't apply in the case of Cyprus. Turkey cited the Treaty of Guarantee as the justification for its invasion, but even if one accepts the Turkish argument, the Turkish armed forces acted in, to use the Latin phrase, ultra vires, beyond their powers. The Treaty of Guarantee only permitted Turkey to take action with a view to restoring the constitutional order established in 1960. Turkey went beyond its powers and thus acted unlawfully. By either physically uprooting the refugees, or the displaced persons, or constructively expelling them from their properties, Turkey had, as the European Court of Human Rights has confirmed, breached the terms of the European Convention of Human Rights. By procuring the de facto segregation of the Republic of Cyprus, Turkey breached the International Convention on the Elimination of All Forms of Racial Discrimination, 1965. Interestingly enough, whereas Greece, the United Kingdom, and the Republic of Cyprus had signed and ratified that 1965 Anti-Discrimination Convention by 1974, Turkey had only signed in 1972 and had not ratified the convention at the time of the invasion. Turkey didn't get around to ratifying that convention until 1994, if I remember correctly, well after the invasion, and even then it ratified subject to the terms of a declaration, the effect of which was that the terms of that anti-discrimination convention would not apply to states with whom Turkey did not have diplomatic relations. In other words, the Anti-Discrimination Convention of 1965, Turkey asserts, does not apply to its occupation of the north of Cyprus. Now, look at the date, 1965. That was a convention that was introduced against the backdrop formed by the Holocaust during the Second World War, in which Jews were subjected to discrimination of the most repugnant kind. It was also formed by the backdrop of events in the southern states of the United States and the civil rights movement. It was also formed by the backdrop of South Africa and apartheid there, and the assertion of white rule in Rhodesia. So Turkey had violated the International Convention on the Elimination of All Forms of Racial Discrimination. Turkey had also breached the terms of the Treaty of Guarantee by occupying the north of Cyprus and procuring a de facto partition. The Treaty of Guarantee prohibits partition. Within days, and I've looked at some of the declassified documents as well, within days of the invasion, Turkey had started bringing Turkish citizens over from Turkey to the occupied area to populate the occupied area. That was a breach of the Geneva Conventions of 1949. Shall I go on? There's one more breach that's worth noting. Turkey endorsed the purported declaration of independence by the so-called Turkish Republic of Northern Cyprus in 1983. Turkey was the only state to recognise that UDI, Unilateral Declaration of Independence, And that, as the United Nations Security Council confirmed, was a breach of international law, and more specifically a breach of the 1960 treaties. So for a multiplicity of reasons, Turkey violated the law and was unable, therefore, to secure a de jure, a lawful partition of the Republic. That sounds like somebody's... So unless my voice has activated something.
I think we might have a spine on it.
So that's all by way of background. And I wanted to make one very important point here, and I'm conscious of the time. Why did all of this law come into existence? Look at the dates of those conventions. The Charter of the United Nations, 1945. Geneva Conventions, 1949. The Convention of Human Rights, 1950. The Convention Against Racial Discrimination, 1965. These were the implements of international law which were designed to prevent a recurrence of what had happened on the continent of Europe during the 1930s and 1940s. And I might add, bearing in mind Asia Minor and the forthcoming exhibition on Smyrna here, which you should all attend if you're available, that what had occurred in the First World War and in its aftermath in the 20s. These were introduced as a riposte by the victorious Allies to illegality and as a means of championing the rule of law. Let me just illustrate that telling point with reference to France. Now, France is traditionally kept out of Cyprus, but with the Eurozone crisis, it's now looming ever large in the domestic politics and diplomatic context of Cyprus. What did the Germans do in 1940, shortly after the declaration of war? Germany invaded France. Large numbers of French citizens were displaced from their homes. They became refugees, to use the layman's expression. The Germans carved up France into zones. The occupied zone in the north, the coastal military zone, which was largely free of citizens. The so-called free zone, which was governed by the collaborationist regime of Marshal Pétain, the lawful government of France, of course, represented by de Gaulle and others, was in exile. The Italians occupied a zone in the south-east, and in the east of France, the Germans not only expelled the local population, but they annexed the territories and also established what they called a zone of German settlement, which was intended to be populated by German citizens in an exercise of the Nazi policy of Lebensraum. You can see the parallels here, and they're eerie. And the word zone, of course, was concocted by Dr. Kissinger and later adopted by Kurt Waldheim. And Dr. Kissinger, of course, is a Jewish emigre from Germany. But one imagines, and I don't know what was in his mind when he came up with the idea of zonality in the mid-70s after the invasion, but one cannot help thinking that he had the activities of Germany in mind during the Second World War when they invaded countries and established zones. And he perhaps also had post-war Germany in mind, which had been carved up into zones asserted by the Soviets, the Americans, the French and the British. So this idea of zonality has the Second World War as its historical basis. And you'll also notice, and hopefully you picked up on this, the other parallels with Cyprus. The occupation of territory, expulsion of the lawful residents and the importation of settlers. That's why those laws exist, because France, being one of the 5 victorious powers and one of the 5 leading members of the security, able to contribute to the affirmation of the rule of law in the aftermath of the Second World War. And I'm now coming to Cyprus. As we know, it's now carved up into 5 segments. The Republic of Cyprus, areas occupied by Turkey, the areas of the Republic which are not occupied by Turkey, the buffer zone which cuts across the middle, and the 2 sovereign base areas. So Cyprus has been carved up into 5 segments. Now we come to the second part of my, the concluding part of my analysis, which is to zoom in on bicommunalism and bizonality and the contradictions at the heart of the Cyprus question. The Annan Plan was defeated, partly, I think, because of the combined efforts of Professor Coufoudakis and I, and the help of the Lobby for Cyprus. We played a small part in the defeat of the Annan Plan. And as a consequence of that, in spite of the defeat of the Annan Plan, the Republic of Cyprus acceded to the European Union in 2004. And it joined the European Union free from the constraints, restrictions and other provisions in the Annan Plan. And as a consequence, every citizen of the Republic of Cyprus, in common with every other citizen of the European Union, belongs to an organisation which is flawed, as we all know. It's in some respects undemocratic, but on paper at least, it is an organisation which is founded, and I quote here from the treaty itself that governs the European Union, it's founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities, because minorities are as entitled to protection as majorities. There's no discrimination permitted, especially on racial grounds, within democratic states such as the ones that we have in the European Union. And these values are common to the member states of the Union in a society in which pluralism, not racial domination as occurred in Nazi Germany, non-discrimination, tolerance, justice, solidarity and equality between women and men prevail. And the Union is also predicated on the basis that there should be free movement of peoples and free movement of goods. And there should be freedom, security and justice without internal frontiers. So the Republic of Cyprus joined subject to these noble values, which represent a response and a riposte to what the Germans had been doing in Europe during the 30s and 40s. And remember, the French were one of the 6 founding fathers of the European Union, and they were very much behind this as a project to prevent a recurrence of the First and Second World Wars. The snag for Cyprus is that in their neighbourhood there are countries which do not share the same values. And even though the Republic of Cyprus legally joined this organisation and legally adopted these values, the culture of the Republic of Cyprus has been very much influenced by its imperial past and by its geographical proximity to the Middle East. And nothing demonstrates this better than the observations of General Ozkok, the commander of the Turkish Armed Forces, in a speech he gave at the Turkish War College on the 20th of April 2005. I took this from the website of the Turkish Armed Forces back then. It's now been pulled from the website of the Turkish Armed Forces for some reason. But this is what the general said in 2005, a year or so after the accession of the Republic to the European Union. In terms of the national interests of Turkey and the responsibilities given to her by international agreements, Cyprus represents one of the main issues about which our concern shall never decrease. The importance of Cyprus from a security point of view is based on 2 fundamental principles. One of these is the security responsibility which we have to ensure for our Cypriot kinsmen, and the second is the importance of the strategic role that Cyprus plays in terms of the security of Turkey, as allegedly, he claims, expressed in the treaties of guarantee and alliance. Now, the whole point of the European Union and the whole point of having a democracy under the rule of law is that people are protected by the law as enforced by independent courts. The mindset of our region in the Eastern Mediterranean is that people are protected by a gun. And regrettably, that mindset has influenced the Turkish armed forces. By extension, it's influenced the Turkish government. And by extension, it's influenced, regrettably, the Republic of Cyprus. Because instead of embracing those noble values in the Republic of Cyprus, they have succumbed to the culture of the region and have entered into a negotiation process which is predicated on two principles, bicommunalism and bizonalism, which are completely contradictory to the noble values of the European Union. And let me now, in the final part of my talk, just illustrate to you why they are completely antithetical. This is what has been agreed by President Christofias wearing the hat he was given as Greek Cypriot leader, according to the United Nations, in his joint statement it published. This is what President Christofias agreed with Mr. Talat in 2008, whilst he was wearing his hat as Greek Cypriot leader. It's a subtle point there, but it's worth grasping. The leaders today reaffirmed their commitment to a bizonal, bicommunal federation with political equality as defined by relevant Security Council resolutions predating the accession of the Republic to the European Union. This partnership will have a federal government with a single international personality, as well as a Turkish Cypriot constituent state and a Greek Cypriot constituent state, which will be of equal status. So the two pillars of this model are bicommunalism and bizonalism. I've already made the point that bicommunalism owes its origins to the Ottoman imperial era. But it has two or three features which are antithetical to European values. The first feature is the one that was articulated by Harold Macmillan, the British Prime Minister, in 1958. Bicommunalism results in administrative partition. So even though the Republic was established in 1960, it was partitioned administratively according to the terms of the Constitution. And this is what the Annan Plan and whatever they've been cooking up in secret is being built on, administrative partition. In 1958, Fatih Zorlu, the then Turkish Foreign Minister, stated that bicommunalism also produces a kind of intellectual partition. What he meant was that one community cannot dominate the other community. But what it also means is that the language that's used in the context of Cyprus is infected with bicommunalism. So we hear everybody, politicians, diplomats, ordinary citizens, referring to the two sides, as if citizens could be carved up into two racial groups. The two communities. The Turkey refers to the two peoples, hopefully they think, as a stepping stone to self-determination for the Turkish Cypriot community. The bicommunal programs. In this country, we've got used to the principles of equality, diversity, and pluralism. What could be contrary to the principles of equality, diversity, pluralism, and I might add, inclusion, than bicommunal programs? How would an Armenian feel if he saw a bicommunal program on education aimed at Greek and Turkish Cypriots? How would a young Syrian Cypriot, who's the son of a refugee from Syria but has a Cypriot passport, feel if he saw a program aimed at Greek and Turkish Cypriots? How would a Russian child with a Cypriot passport feel in that context? We have a population in the Republic of Cyprus now which contains a migrant or non-Cypriot refugee population that has reached 18%, according to the latest census. 18% of the population, the lawful population, I should add, of the Republic of Cyprus, consists of non-Greek Cypriots and non-Turkish Cypriots. This isn't the Cyprus of the 60s and the 70s, when bizonalism and bicommunalism were all the rage. We're talking about a completely different entity. The Lidra Street in Nicosia is like Holloway Road. And I see people nodding. How are we going to integrate the new migrants, the refugees from Syria, the refugees from Afghanistan, the Pakistani lad who's lived there for 10 years and has picked up a passport? How are we going to integrate these people if we are trapped by the intellectual partition of bicommunalism? And I want to finish by 5 minutes? Another 5 minutes. That's what's wrong with bicommunalism. It's contrary to the very pillars of European identity. Of course, Professor Coufoudakis worked for many years in the United States. The Americans have the same pluralist culture. That's why President Obama has now become president for the second time. These aren't necessarily European concepts. These are liberal democratic concepts which we in this country benefit from. Mr. Frangeskides is a partner in one of the biggest firms of solicitors in the City of London. His name, Frangeskides, hopefully, has not counted against him or in his favour. He's reached the pinnacle of the legal profession by virtue of his credibility as a lawyer, his education before he qualified as a lawyer, and his character. Professor Coufoudakis reached the pinnacle of the university system in the United States by virtue of his character, his qualifications, his credibility, his scholarship. Not because he was called Coufoudakis or because he was Greek or any other factor that's unnecessary. The Annan Plan, as the 1960 Constitution functioned, was predicated on people reaching positions of power because of their race or religion. This is completely anathema to modern European principles. So enough of that. I've said hopefully enough on bicommunalism to demonstrate how dangerous it is. But let me now close with bizonalism, because this is the most chilling feature of this concept. Can you see the signs there, by the way? I'll come back to those signs right at the end. But that is a sign of the ethical deficit at the heart of the Cyprus question. And it's also a reflection of how everybody has just accepted it. The United Nations, the Republic of Cyprus, the other guarantor powers. I showed that to my colleagues at the university today and they were horrified. But what makes bizonalism most chilling of all is the approach that Turkey has taken towards it. If I can just take you to the next page. Now, Turkey uses oblique terminology. That's diplomatic terminology to describe bizonalism. Turkey states that the Cyprus question must be settled on the basis that restrictions will be placed on three freedoms: freedom of movement, freedom of settlement, and freedom of property. Of course, that goes against every principle of capitalism, goes against every principle of the European Union, goes against every principle of living in a liberal democracy under the rule of law. We are all, those of us who are European Union citizens can go anywhere in Europe to buy property, open a business, trade and so on. What's chilling about bizonalism is how Turkey interprets it behind the scenes. Now, I thought long and hard about drawing upon WikiLeaks, but I'm going to draw upon WikiLeaks because there's one document that reveals the essence of bizonalism. And this is a document prepared, it seems, by the American ambassador to Nicosia. but it was certainly issued, according to the WikiLeaks document. It was issued by the United States Embassy in Nicosia and transmitted to Washington, D.C. And if I've got this correct, the meeting was attended by the United States Ambassador in Nicosia and Mr. Sakir Fakili, the so-called Turkish ambassador to the so-called Turkish Republic of Northern Cyprus. So they had lunch, and this is what diplomats do after they have lunch. So if you ever go for lunch with a diplomat, remember it will be probably recorded and sent off somewhere. They had lunch, and the ambassador went and wrote down what he thought of the meeting, without knowing that it would end up in the Hellenic Centre in Marylebone a few years later. On bizonality, a key Turkish Cypriot demand, Mr. Fakili, this Turkish diplomat from Turkey, thought there would be no residential mixing of Turkish and Greek Cypriots post-solution. He quickly clarified his comment, knowing that he said something he shouldn't have said. He quickly clarified his comments, however, stating that there would be ceilings that limited Greek Cypriot settlement in a future Turkish Cypriot constituent state. Note, our pro-solution Turkish Cypriot contacts, both in Talat's office and in the so-called Ministry of Foreign Affairs of the TRNC, claim that Turkey wants as ethnically pure a Turkish Cypriot state as possible, even if this means giving up more territory in return. All I can do in response to that is draw to your attention to what Martin Luther King said before he secured the Nobel Peace Prize in 1964. Segregation ends up relegating persons to the status of things. Hence, segregation is not only politically, economically and sociologically unsound, it is morally wrong and sinful. Dr. King campaigned against the signage and the culture that was prevalent in the southern states of the United States, as one can see from that sign that's been published by the United States government. That's a sign in Georgia in 1943. The middle sign is from apartheid South Africa, and it's used in educational materials published by the United Nations. And the sign on the right tells Greek Cypriots to turn left and Turkish Cypriots to go right. I understand at the Lidera Palace checkpoint, which is maintained by the United Nations. Segregation is not just morally wrong, it's unlawful. It's contrary to the International Convention on the Elimination of All Forms of Discrimination, racial discrimination. You can read the provision in your own time. But it states that the parties to the convention particularly condemn racial segregation and apartheid, and undertake to prevent, prohibit and eradicate all practices of this nature in territories under their jurisdiction. I'm approaching 9 o'clock, so I will just draw your attention to additional provisions of European law which reinforce and build upon what the 1965 International Anti-Discrimination Convention stated. Article 1 of Protocol 12 of the European Convention of Human Rights 1950 came into force as recently as 2005. This provides that the enjoyment of any rights set forth by a law shall be secured without discrimination on any grounds such as sex, race, colour, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth or status. No one shall be discriminated against by any public authority on any grounds such as those mentioned above. And Turkey, by the way, has not ratified that convention provision. And the European Union's Charter of Fundamental Rights establishes a similar principle and says that everyone is equal under the law and as a consequence, all those forms of discrimination are unlawful. And that, of course, forms the backdrop to the bill currently going through Parliament, which will ensure that if Prince William's first child is a daughter, that daughter will inherit the throne of this country, because we've decided as a country to move on from the discriminatory practices of the past. So, hopefully I've demonstrated here the bankruptcy, the moral bankruptcy and the legal questionability of bizonalism. I'm now going to close, ladies and gentlemen, and draw your attention to some fundamental principles and then offer 2 or 3 thoughts before we throw things open to discussion. I began by referring you to Aristotle's Ethics, but in his other book, Politics, he reminded us that man, when perfected, is the best of animals, but when separated from law and justice, he is the worst of all. And Aristotle in Ethics reminds us that the law is not just a cold, blunt instrument. The law must be associated with justice. And this is what they can't understand in Cyprus, I regret to say, the political class at least. They think that whatever they cook up in secret will be lawful, because it will represent the law. But Aristotle and the Western liberal tradition reminds us that the law, to quote an American judge, must float on a sea of ethics. And this is the theme that Martin Luther King picked up, because the law in the southern states of the United States permitted that racial segregation. The law in South Africa permitted those signs to be put up. The law in Nazi Germany was inherently discriminatory against Jews and Gypsies and others. And in the European Union, as part of the Western liberal tradition, we've decided that the law should not be whatever the politicians say it is, but the law should be inherently just and ethical and moral. The second concluding thought is from our own Lord Chief Justice in this country, Lord Judge of Draycott. Lord Judge was born in Malta to a Maltese mother during a German air raid. His father was English. He came over to this country. He educated himself, became a very senior judge, and is now the most senior judge in this country. He is Lord Chief Justice and head of the judiciary. He reminds us that where the rule of law ends, tyranny begins. It is an adaptation of the great phrase of John Locke. And it's interesting that the President of the Supreme Court of this country is Jewish, Lord Neuberger, and the Master of the Rolls of this country, Lord Dyson, is also Jewish. And the Lord Chief Justice, who is the head of the judiciary and the top judge, is Maltese by birth and by his mother. You can reach the top in a multi-ethnic society irrespective of your background, and that is how the Cyprus question should be resolved. It should be resolved on a multi-ethnic, unitary, democratic basis that's predicated on the rule of law. And I've mentioned the Jewish background of those 2 judges. My eye was caught by a rather interesting statistic. In 1966, there were no more than 30 Jews on the island of Cyprus. Today, there are approximately 2,000. Since 2005, Cyprus has had its own chief rabbi, its own synagogue, even its own supplier of kosher food. The Jewish community is expanding. I understand for various reasons. One is that there are Israeli citizens who are coming over for business purposes. There are British, French, German citizens who are leaving Germany or France or the UK and going to live in Cyprus. And interestingly enough, as I understand it, from what I've heard anecdotally, there are some Israelis who are eligible for a Polish or a Lithuanian or an Estonian passport in view of their backgrounds and connections to those countries, and they're picking up their passports from the Lithuanian embassy or wherever it is, whichever European Union embassy it is, and they're hopping over to Cyprus to escape the conflict the conflict with the Palestinians, but to stay within the region. That community is growing. How can we be talking about 2 communities? We must surely be talking about one community under the rule of law. One community with several languages, with Greek and Turkish perhaps enshrined in the Constitution as the two primary languages, with Islam and Christianity given certain rights in certain spheres. But we shouldn't build a constitution around Christian Greeks and Muslim Turks. And this reminds us of what Anthony M. Kennedy, the United States Supreme Court Justice, said. When we talk about the rule of law, we assume that we're talking about a law that promotes freedom, promotes justice, and promotes equality. Justice Kennedy is Roman Catholic. The President of the United States is Barack Obama, and he is of mixed race background. And earlier this week he was inaugurated to become the President for the second time, and he said a few things that I'd like to read out to you today to close my contribution. And these are the guiding principles I would submit that ought to be planted into Cyprus to replace bicommunalism and bizonalism. Each time we gather to inaugurate a president, we bear witness to the enduring strength of our constitution. We affirm the promise of our democracy. We recall that what binds this nation together is not the colours of our skin or the tenets of our faith or the origins of our names. What makes us exceptional is our allegiance to an idea articulated in a declaration made more than 2 centuries ago. And it was a declaration, I might add, that was influenced by the ancient Greeks generally and by Aristotle in particular. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. I can do no better than close with President Obama's words. Thank you.